My lord,
Extending, my lord. My lord, it's the section 24 application, my lord.
Section 24, hand over this.
my lord, a day before yesterday, my lord, my matter was taken up, my lord. The respondent appeared without caveat, my lord. Sought copy of your lordship was pleased to direct me to serve copy, my lord.
Yes.
I have thought today, my lord, my matter is appearing as 134, my lord. There is some urgency, my lord.
Yes.
It was 32 day before yesterday, my lord.
What is the urgency?
My lord, the urgency, my lord, I am suffering an execution proceeding. I am the husband.
All right,
based-
let me see. Yes.
Yes,
May I be allowed to mention item number
Did
120?
not hand over the slip. It's appearing in the list.
May I be allowed to mention item number 120 of my lord's daily list?
Yes.
So the urgency is this, my lord. That an order of injunction has been passed against me where I am putting up construction my own property. I am my property is not even the suit property. The suit property is being used by me for only by ingress and egress. Showing that my lord the plaintiff obtained an order of injunction. But I have made an application order 26 rule 9 for inspection. That application is pending, and in the meantime, the police application is allowed for implementation of the order, and my entire construction is stayed. So I am putting up the construction on my own
All right,
property.
please mention on Monday. Yes.
My
Call the
lord,
list.
under compelling
Your lordship,
circumstances, my lord, may I mention, my lord, item number 105, my lord.
Yes.
My lord, this is with regard to sand mining of rupees 30 lakhs filed before Civil Judge Junior Division, and due to an injunction order, my lord, I could not, my lord, continue the sand mining, and government has already issued termination notice in my favor.
Yes.
Now, my lord, I filed an application under Order 7, Rule 10 before the learned court below. That has not yet been heard, and
What is the next date fixed?
next date, my lord, fixed on, my lord, 21st of May, my lord.
All right, let me see. Yes, call the
my
list.
lord,
You did not hand over the slip. Yes.
my lord, I will.
If this
Yes,
matter, my
I
lord,
will
can be
inform my other side, my lord, because since they are appearing. So may I know your lordship will take up today or
Yes. Let me see how far I can proceed today. Yes.
grateful.
This is a my lord, eviction suit is of 2012.
Yes.
2012, my lord, 7 to 5, that is still pending for consideration.
Yes.
Your lordship was pleased to dispose of this divisional application, requesting the learned trial court, my lord, to dispose of the 70 application as expeditiously as possible, and considering the age of the suit, your lordship was pleased to direct the learned court below, my lord, to dispose of the suit
As expeditious, yes.
within 9 months, as expeditiously as possible, preferably within 9 months. In the second order, in the second divisional application, it has been recorded. If you will also kindly have a look at this. Similar order was passed, my lord. In the second page. This is also my common landlord suit is of 2012. These 9 months, my lord, has been, my lord, to some extent, my lord, not, my lord, typed out. Common landlord, self-same suit property, only two different tenants. That is the reason why, my lord, two suits.
Ashwin.
My lord, this is my application for extension of interim order, my lord.
Yes.
In this matter, I have served the copy and the application has been filed in time.
Right, Adil?
Your Lordship,
And the next
cur-
date is 7th May, my lord, before the learned trial court.
Your Lordship, if I may, the current impugned order was passed on May 2nd. It has been a year since the interim order has been extended continuously. Could you please kindly fix a date for the final
It
hearing?
can be fixed, my lord. I am ready for the hearing.
Yes, my lord. And
In between, the matter can be extended, the interim order.
please kindly, it is my request to extend the interim order to the shortest date possible, if Your Lordship may.
You have filed an application for extension of interim order.
Yes, yes.
The
But I
interim order
filed
is-
the application on 28th April, whereas the order was valid till 30th April. So well within time, I have
30th of April of
30th April of 2025.
uh,
Well, the last
can,
order of
can
your
3 of
lordship, yes,
2025.
can two.
No. This application you have filed can 3 is this.
This is can three. This is can three.
Can 3 তে একটা order করে দিন this
Well, I will petition our Lord. Interim order expired on 30th April. Lord, I have served the copy up in the other side. May please, your Lordship.
you have filed an application.
No.
Uh,
Lord, may I only please this? Lord, in terms of this order, because we were not represented, my Lord, there's a lot to say in the matter. It's
Not
not been
to-
represented properly. My Lord, there's an order of
Lord,
status
I'm
quo.
putting it for hearing.
Kindly do that, and my Lord, we
The
need to file an affidavit in opposition. Only one indulgence, but there's a prayer. On the last day, if your Lordship kindly takes up the order, the direction in paragraph 3 maintain status quo.
yes.
We have a decree in our favor in respect of this property. That's not disclosed in this present suit. From where, my Lord, this
Already you filed
only this status quo will apply to both the parties. My Lord. They are continuing with the construction.
modification will. I'm extending. I'm fixing it for hearing.
My Lord, in the
Me,
meantime, kindly permit us to file the affidavit. We'll bring on record, my Lord,
Affidavit in opposition.
in opposition, my Lord.
The
Status quo, my Lord,
what
will
the
be-
learned advocate
Milord, Milord, this matter was heard time to time when interim order was extended, Milord.
1, 2, 3, led by Mr. Jonathan.
Milord, I have respondent number 4, but I am the executor
You
of.
filed an application for extension.
Yes, Milord.
Uh,
I have
can
copy upon them.
3 of 2025. Five.
I am appearing on behalf of the petitioner, my lord. The interim order expired on February. And I filed this application.
Have you served a copy of this application?
My lord, after
Have you served a copy of this application?
I mentioned this matter for inclusion in the list on Wednesday, and on Wednesday I served. Wednesday I served, but
Where is the affidavit of service?
affidavit of service is not made, my lord.
The petitioner is directed to serve a copy. Yes, Mr. Rai.
This matter, my lord, I'm appealing for on behalf of this opposite party number 1 and 2, my lord. My lord, just now I have received the, my lord, brief. My lord, there is a absolute, my lord,
It's appearing in the list as contested application.
This is evidence service.
Mr. Rai, it is appearing in the list under the heading contested application. It was directed to appear in the monthly list of April.
Yes.
It's appearing. It is appearing. All right.
there is a, my lord, submission of all the facts, my lord, also.
Indicate that when it will
Yes,
be taken up.
The petitioner yellow. Mr. Minal Kanti Ghosh is appealing for the petitioner yellow.
Yes.
As he on his legs before Kotu number 2, I'm praying for not today, yellow.
Pass over next. Ask him to come. Yes, next.
8.
My lord, I am for the petitioner, my lord.
Yes.
My lord, what has happened, my lord, in this case, a partition suit has been filed by the petitioners as plaintiff against the defendant, my lord. My lord, in that partition suit, my lord.
Partition suit, you are the defendant.
Partition suit, I am the plaintiff.
You are the plaintiff. Yes, what
My lord, my lord, I am telling you, lawsuit, because a contempt application has been filed, my lord. My lord, what has happened, my lord? An application for
contempt application has been filed against you.
Yes, my lord.
Yes.
My lord, an application for injunction was passed, my lord. Where the learned court has been pleased to direct both the parties to maintain status of the order, my lord. My lord, in the meantime, what has happened, my lord, during COVID period, my lord. My lord, there was the elder brother of the appellant number of the petitioner number 1 has suffered from COVID, my lord, and money was necessary. Well, finding no other alternative, and at that point of time, the court was closed and the learned advocates were not available, but they sold a fractional share of the property to a stranger, my lord. That was also
you have sold,
my lord. Although, my lord, my lord, they vehemently oppose the injunction order, my lord. My lord, in the meantime, they filed an application for contempt, my lord.
Order 39 Rule 2A.
Order 39 Rule 2A, my lord.
Yes.
My lord, in that application, my lord, in the peremptory hearing, my lord, some documents is necessary to
What
show
are the
the
documents?
treatment papers. Because, my lord, the petitioner number 1's elder brother has died out of COVID, my lord.
Yes.
In the Bellevue hospital.
From whom? You direct whom to produce these treatment papers?
But that is before the hospital, my lord. Hospital. Because, my lord, that those papers are not available, my lord, I filed an application to call for the records, to produce the records, my lord. And, my lord, that is a permissible, my lord, under the law. Order 16, my lord, he can produce. And, my lord, if there's a secondary piece of evidence, my lord, section 65 of the Evidence Act, my lord, unless I give notice, my lord, to the
Yes.
party, I cannot produce those documents. And court,
You have the secondary evidence with you.
yes, my lord, xerox copy.
You have given a notice. It
No,
does
that
not
is
say-
the application I have filed.
Order 16 Rule 6 is a different thing altogether.
My lord, I have
Summons to be served.
my lord, read it,
Section-
section 65 of the Evidence Act, my
Section
lord.
65 says notice under section 66. Section 66 and order 16 Rule 6 is a completely different procedure.
My lord, your lordship, I have to produce the secondary piece of evidence, my lord.
That is for you to take steps. You have to take
My lord,
appropriate steps.
my lord, I have taken, my lord, your lordship, kindly consider, unless I show the treatment papers, my lord, I cannot.
You can show, you take steps accordingly.
My lord,
That is-
steps, my lord, to waste, my lord, your lordship, kindly consider, my lord. My lord, nomenclature is not the factor, my lord, your lordship, kindly see. Your lordship, kindly see my paper.
So if you have complied with, produce secondary evidence.
My lord, landed court is not accepting, that is the thing, your lordship, kindly see.
These,
Landed court is a misconceived application. Yes, stated.
on that application, that order will not. Mr. Gupta, the section, the evidence sector. Section 66 is a different thing altogether.
Section
It does not require you to file an application in the court. Please come to section 66.
Yes, my lord.
Yes.
My notice has to be given, my lord.
Upon whom?
To the party.
Yes. But you have filed this application before the court.
My lord, court will serve notice. Court will direct.
That is
My
what the-
summons has to be produced, my lord.
No. That is why I'm saying that is order 16 Rule 6. That is the procedure you are adopting.
My lord, order
Please
16
come
Rule
to-
6. My
please
lord.
come to section 66 of the Evidence Act.
My lord, your lordship, kindly consider order 16 Rule 6. I filed the application read with order 16 Rule 6, my lord. Your lordship, kindly see my petition.
Mr. Gupta, that is not the procedure. That is not the procedure. If you want to lead secondary evidence, you have to take steps under section 66. And section 66 does not require filing of an application before the court.
My lord, your lordship.
Notice upon the opposite parties.
My lord, your lordship, kindly grant the liberty, my lord. Otherwise, my lord.
What liberty?
My lord,
Liberty is always there.
My lord, your lordship.
I am clarifying that. This application under Article 220
petitioner, my lord.
Yes.
Opposite party can,
Good.
caveated.
You are for the caveator.
Plaintiff.
You have been served with the copy.
Yes.
Yes.
My lord,
Yes.
a suit for eviction of a licensee was decreed. It was decreed on 15th December 2014. Thereafter, an execution was put in, and the execution was disposed of by the possession being delivered on 27th January 2017. During the execution proceeding, there was resistance. We preferred an application under Order 21 Rule 97 for police help that was registered by the opposite party. That was ultimately dismissed and we got the possession. Now, a miss case under Order 9 Rule 13 was filed on 19th April, which was dismissed. Your Lordship kindly sees the order passed by the trial court dated 11th of February, I just stand corrected, dated 31st of March.
What is the ground on which it was rejected?
It was rejected because summons were properly served. It was held, summons were properly served. Second grounds, already the execution was satisfied, possession delivered. At that juncture, they preferred a suit. They instituted a suit for specific performance, which and there was a they tried to say that this was a suit for specific performance.
Show me that recording that the summons was duly served.
Yes, my lord. Kindly come.
Show me that finding.
The defendant entered appearance, that is admitted.
Your Lordship kindly sees the order dated 19th April 2024, passed by the trial court.
No, so it's not a case of non-service of summons.
No.
So it's a case of after appearance they failed to
They
take
failed to
steps.
set.
So what is the finding on that?
Finding, they say, Your Lordship kindly
No, the court's finding. I want to know the court's finding.
Court's finding. They have knowledge. They wanted to impress that.
Show me which paragraph, which portion.
Order dated 19th April. If Your Lordship in the next certified copy, next order for considering the application under Order 9 Rule 13.
Yes.
The court has to only consider the expertise degree was passed without service of notice of the original suit, and there is sufficient reason shown by the petitioner, defendant, judgment debtor that his conduct was not willful.
This is what is to be done by the court. Next paragraph. Come to the next paragraph.
Both parties adduce their respective evidences to substantiate their pleas. Admittedly, petitioner defendant appeared in the main suit but did not file WS. An expertise degree was passed in favor of. The opposite party plaintiff filed execution and miss case for police help. The petitioner defendant judgment debtor appeared in the miss case and OP get possession of the decretal property. Third point, plaintiff all along wanted to impress upon this court that decree has been satisfied in full and it will be pointless if the suit is restored to its original file. Thirdly, now file this case in order to allow him to contest the original ejectment suit and or to restore the ejectment suit. Now, if the case in hand is allowed, what would petitioner do contest which has already been satisfied? Moreover, the petitioner judgment debtor has not been able to convince this court that he was diligent throughout the trial and execution proceeding, but made an attempt to impress this court by filing an afterthought story that it was all the fault of previous counsel. The fact, if true, must ought to be brought to the earliest, or else proving and believing the same will most difficult. The contention is that learned advocate did not act in.
What is the finding of the appellate court?
Well,
So this has been set aside in appeal.
Appeal, my lord.
Where is the
Appellate court? Your Lordship only says that satisfaction of degree. Your Lordship can come. Order is of 31st January 2025.
yes?
May just skipping few paragraphs from the copy of the impugned order. It appears that the application under Order 9 Rule 13 filed by defendant for setting aside expertise order in suit was dismissed mainly on the ground that the plaintiff has already got possession of the decretal property by virtue of the execution case filed for executing the decree, and if the decree be set aside, the petitioner defendant has nothing to contest the ejectment suit, which has already been satisfied inter alia on the ground that the defendant has not been able to convince the court that he was diligent enough to contest the suit. At the time of argument of hearing, it was highly contended by the learned advocate to the appellant that while considering and deciding an application under Order 9 Rule 13, the merit of the case cannot be looked into. From the copy of the moment, the only ground the appellate court said that there are other grounds also, diligency, putting blame on the learned advocate. Learned decree was passed, thereafter contesting the police help application. At that point of time, they were not blaming the advocate, and only an afterthought that advocate was not diligent enough. That is the ground which the court disbelieved. And your lordship, at the time of argument hearing, it has rightly contended by the learned advocate that from the copy of the impugned order, it appeared that the learned trial court had observed that miscase filed by the defendant is a misconceived one, and its restoration will not serve any fruitful purpose. Though the learned trial court has simply hold that the defendant has not been able to convince the court that he was diligent throughout the trial and execution proceeding, but made an attempt to impress the court by filing an afterthought story. That is the reiteration. And from the case record, it appears that a complaint was made by the defendant against his engaged lawyer to the local bar association for not discharging his legal obligation as duty as an advocate to contest the suit. The present position of law is that when deciding an application under Order 9, Rule 13, the court generally cannot consider the merit of the case. The primary focus is whether the defendant has sufficient cause for their non-appearance, not whether they have a strong case on merit of the dispute itself. Having considered the above all, having considered the materials on record, it appears that sufficient cause is made out by the appellant defendant for setting aside expert order. I fail to understand what is the sufficient cause.
Yes, what do you say?
My lord, already, my lord, it's not that, my lord, no steps have been taken, my lord. Steps have been taken. It's not.
What steps did you take?
My lord.
What steps did you?
That is, my lord, recorded from the case record. It appears, my lord, that a complaint has been made for by the defendant against his engaged lawyer to the local bar. My lord, it's not that, my lord, only a blame has been put and nothing to substantiate that blame. My lord, steps have been taken, my lord, in the meantime, my lord, against the good or bad, my lord, that is pending, my lord. And my lord, what the appellate court, learned trial court's only contention is that, my lord, position has already been delivered, so there is none.
That cannot be a ground.
My lord, kindly considers if my lord, I have, my lord, my lord, if my lord, if
That
I am
cannot be a ground for rejecting.
my lord, if I am, my lord,
Why?
my lord, kindly considers if I am, my lord, able to successfully, my lord, contest this suit and, my lord,
The degree has been executed.
get a degree. My lord, there are provisions, my lord, to
What provisions?
for restoration of position, my lord, I can always, my lord, apply, my lord, after, my lord, the decree is, my lord, my lord.
Anything more?
No, that is.
Ashun, this application
recovery of possession, my lord, filed in the year 2020.
What are you praying?
My lord, expeditious disposal.
What is the stage of the suit?
My lord, the cross-examination of PW1 is going on since
This
19th of
application
September.
under Article 2.
For the petitioner. I'm saying the matter may be taken up on 7th, but I'm on caveat. But the advocate on record, due to his personal difficulty, could not have given the brief to me. If the matter can be taken on 7th.
May I just not indicate to my learned friend, it might be helpful to him. But they filed a suit against my client, the defendant, seeking recovery of money for the services rendered by my client. The suit is valued about 19 lakhs. The suit was filed here in the West Bengal. I took a plea that there is a lack of territorial jurisdiction, and accordingly I took out an application under Order 7, Rule 11. Apart from that application was turned down by the learned court, and I am before your lordship. Now, my lord, I have a better point.
Can it be decided, Mr. Mukherjee, in Order 7, Rule 11, whether the court lacks territorial jurisdiction?
But my argument will be, Lord, the court should have kept it open instead of deciding it. I bow down to your lordship. It is a mixed question of fact on law, whether the cause of action is adhesive. But more why I say, because I asked my learned friend to wait, there is a point out section 69 which I am going to take, relying upon a Supreme Court decision, which might, my lord, bar his suit. It is an unregistered partnership seeking recovery of money.
First of all, did you take that point?
I did not, but I might
Have you
because of a
gone-
Supreme Court judgment.
Mr. Mukherjee, have you gone through the recent decision of the Honorable Supreme Court
Your lordship is
rejecting the plain in exercise of powers under Article 226 and 227 delivered, I think, day before yesterday?
that I did not. Lord. That I did. Day before yesterday, I did not.
So, and this is so, if you have not taken this point, so now under Article 227, I have to decide that and reject the plain for the first time on that issue.
I have, Lord, another better point, Lord. I
can
conferred
give
with
you
my client.
liberty to raise all points because that was not the point.
My learned friend agrees. I have a talk with my client, Lord. If they go for a mediation, they can settle. To be very honest, Lord, my client says that, Lord, what they are asking for, that is too high an amount. We can pay them what that is lawfully due to
You
them.
can always take instruction since my learned
Right.
senior is suggesting that I am nobody to oppose that. Let them take instruction.
Because I have opened up my case, Lord, so that they understand what I mean to say.
When can you take instructions on mediation?
Next week, immediately I will inform the advocate on record that
After some argument, Mr. Mukherjee, learned senior advocate appearing for the petitioner, submits that the disputes between the parties may be settled through mediation. Or I can record your agreement to go before the mediator because they
kindly record my submission that
after some argument, Mr. Mukherjee, learned advocate appearing for the petitioner, submits that the petitioner is agreeable to go before the mediation for resolution of the disputes involved in the suit as well as in this civil revision application. First up, the learned advocate appearing for the opposite party caveated seeks time to take instructions in this regard. First up, in view thereof, list this matter under the heading for us. Wednesday for us. Yes, next. If it is service filed in today, on record. Yes, call the next matter.
My lord, I am for the petitioner, my lord. This is appearing for the first time. My lord, this application is again challenging the order dated 6th of January 2025, wherein, my lord, the order 1 rule 10 petition filed by the petitioner has been rejected by the learned court, my lord, wherein they have prayed.
What is the suit for?
My lord, suit for partition and, my lord, permanent injunction, my lord.
In such a suit, whom do you want to add?
My lord, this Raghunath Chatterjee, my lord, who is making the construction in spite of there is a status quo order.
Does he have a share in the property?
He does not have
who
a
can be parties in a suit for partition?
But my lord, kindly consider, my lord, the defendants have engaged this Raghunath Chatterjee to construct a dwelling house on the base portion of the land, my lord.
This application under Article 227 of the Constitution of India is at the instance of the you are the applicant or you are the plaintiff?
I am the plaintiff, my lord.
Is at the instance of the plaintiff and is that
Dependent number 5, petitioner before
Yes.
my lord, suit for partition. My lord, the status quo order was passed, my lord. Therefore, I filed an 150 application for construction, my lord, in the suit property, my lord. That was rejected, my lord. My lord, kindly see my application, my lord.
there are two things. 151 permission cannot be granted without modifying. Then it's an appellable order. Though captioned as one under 151, in effect, you are trying to modify that order with a prayer for permission. So it's in effect order 39 rule 4. Though you have captioned it as under 151, that is one. And on merits, have you raised any construction?
Started, my lord.
Started. What materials have been produced to show up to what level
my-
you have
my-
made construction.
my-
Any local inspection held?
Is my lord, that was held, my lord.
Any local inspection held?
No, commission report was given.
Commissioner's report was there. What did the commissioner say?
That is not with me, my lord. Well, kindly see the order, my lord. Kindly see the impugned order, my lord. That is
What's
there.
the reasoning in the impugned order?
Reason, my lord, only I am not given the specific details of the measurement of the small.
Has
house.
to be, because whether you are making construction within your share, exceeding your share, best portion of the property, that facts are to be taken note of. You cannot be allowed to make a construction exceeding your share. Rightly.
But I have given undertaking, my lord, that I will not.
Undertaking will not do. Undertaking, you will demolish, but in the meantime, you will enjoy a larger chunk of the property in excess of your share.
Well, my lord, then, my lord.
Rightly rejected.
My lord, kindly direct them to my lord, reheard this matter, my lord. I will give all document, my lord, all, my lord.
So where is that? Says that you have not indicated. That does not appear from the impugned order.
What, my lord?
That you have not indicated the measurement and
My
other
lord,
things.
kindly see, from the petition, it transferred that, my lord, the impugned order.
From the petition, it transfers is lacking in specific cases.
Specific details.
Rightly. This application.
Well, 14th and 15th, both. One matter, I petitioner is a plaintiff, and one matter petitioner is a defendant. A licensee period already. What
do you want?
One manner, one injunction application, extended the interim order time to time. Though the licensee period, 20 in 2023 already expired. Before that, the licensee file an application and
you have want expeditious hearing of the suit.
One matter.
Yes, so.
One matter, the injunction. Though the
what is this matter? First, let us.
Experience disposal suit
of your suit.
My already
what is the state
same
of the
date, but the ex parte fix.
ex parte hearing of the suit.
Ex-parte
What
hearing
the
fix.
defendants are not contesting.
Same date, but one matter is appearing, one matter is not appearing. Because after decree file order 9 rule 30, extend license period already lapsed in February 2023. Already expired.
No, this was fixed for ex parte hearing on 7th of February 2025.
The 30th June 2025.
30th June is the date fixed for ex parte hearing.
Yes.
And that was done by an order dated 7th of February.
Yes, madam.
So did they file any application for vacating this ex
No,
parte?
no. That is, well, earlier also there is no filing an application for vacating this.
No, this is the first date on which it was fixed for ex parte
No,
hearing.
no, earlier several date.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned trial judge, praying for a direction upon the learned civil judge senior division second court at Barasat to dispose of title suit number 1001 of 2023 expeditiously. So stop in view of the order sought and proposed to be passed. Next, from the order sheets appended to this application, this court finds that the learned trial judge by an order dated 7th of February 2025 fixed 30th of June 2025 for ex parte hearing of this said suit. First of the learned advocate appearing, Mr. Mukherjee, learned advocate appearing for the petitioner submits that no application for vacating the order dated 7th of February 2025 has yet been filed. First up, in the light of the said submissions made by the learned advocate for the petitioner, CO number such and such stands disposed of by requesting the learned civil judge senior division second court at Barasat, District 24 Parganas North, to proceed in accordance with law, to proceed with title suit number 1001 of 2023 in accordance with law and make an endeavor to see that the same is disposed of as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Either of the participants. Yes, next.
No.
So the next matter, what is this matter?
That matter, the defendant filed the suit for this matter. I filed an injunction application.
That is pending.
Pending.
So you are the defendant in this suit.
Defendant in this suit.
This what is the next date fixed?
30th June.
No, you filed an injunction application or you filed the order 39 rule 4?
Order 39 rule 4.
Say so.
Under Order 9 Rule 13 below. Along with section.
Has to be.
Yes, my lord, but
If you execute the decree in the meantime,
yes,
the application will become infructuous.
but my lord, he is occupying a two-story building at Bhatpara municipality. Eviction of licensing. Without any occupation charge, my lord.
Did you file any objection to the stay application? Did you pray for occupation charges before the Lanet Court trial judge?
On the verbal objection.
Verbal objection.
Kindly, my lord.
What is the next date fixed?
On the 14th of July, my lord.
14th of July for orders in the miscellaneous case. Your voice was not that loud enough. You did not file any objection to the stay application.
Appealing for the petitioner, Lordship.
Yes.
Lordship, award was passed under the MSME Act. Lordship, will hear me for 2 minutes the facts, Lordship. MSME Act, and I had put into execution before the commercial court at Rajarhat. The learned commercial court at Rajarhat, on a ground of maintainability by the judgment debtor, had dismissed my execution application on the ground that it is beneath the pecuniary limits. It is lesser than 30 lakhs. Why it is lesser than 30 lakhs? The awarded amount, principal plus interest, is 60 lakhs. Plus, but the learned court has segregated the amount and has said the principal is lesser than 30 lakhs. And that is why the execution was dismissed. Immediately, without challenging that order, I had filed an execution. The same execution was filed before this honorable court, to which, Lordship, I'll indicate the order of the order passed by this court in the execution. Lordship will come to page 70. This is the final order. Several orders were passed.
Page
70.
Yes.
Lordship will come to second page, page 2, first. According to the commercial court, the claim of 30 lakhs and did not have the pecuniary jurisdiction to enforce the award. Liberty was granted to the petitioner to approach the competent court, and the benefit of section 14 was also taken. The petitioner did not challenge the award, instead filed the application for execution of the award on the self-same pleadings. Now, Lordship will see the next paragraph. Mr. Shah, learned advocate, submits the learned commercial code erroneously held that it lacked pecuniary jurisdiction. Pecuniary jurisdiction should be computed on basis of the sum awarded and not the original claim. Now, thereafter, Lordship will see next page towards the middle. In the midst, the execution was withdrawn. Lordship had got that. Next page, page 3, internal page 3 of the order. In the midst of arguments, upon instructions from his client, the client will withdraw the execution, take appropriate steps challenging the order passed by the learned commercial court at Rajarhat. Now, that was withdrawn. Thereafter, Lordship, I filed a SLP against that order, against the order of the commercial court at Rajarhat, which is at page 77.
SLP against that or SLP against this order?
Against, not this order, against the order that was passed in execution proceedings. There was no appeal provision. That is why I prefer an SLP. Now, the Supreme Court have granted liberty to approach this court under 227.
Where is
page
that?
77. 77, Lordship, we are not inclined to entertain the special leave.
Pursuant to that, you have challenged this.
Challenge this. Now, Lordship, the point is this. The award, I have the judgment of the Supreme Court. It's a 3-judge judgment, which says the awarded amount, it's not, it cannot be segregated. Paragraph 27 to 31 of June, Lordship will give.
Let it appear first.
Very good.
Yes.
Thank you.
The 3 proceedings are going on between the parties. I am the husband. Here I am the petitioner. My lord, in maintenance proceedings, my lord, an amount was awarded. In domestic violence proceeding, an amount was awarded. And divorce proceedings also, my lord, section 24 filed by the opposite party, and my lord, some amount was awarded. So I am paying regularly, my lord, the highest amount, that is rupees 10,000 per month. But in the execution proceedings made in the 125 proceedings, thereafter, my lord, in mat shoot, my lord, I have shown the say challan that I am regularly paying 10,000 rupees. But the learned court was very much pleased to stay the entire proceedings. That is my grievance. The amount should be adjusted. It is the present position of law. Your lordship knows very well better than me.
So you have not paid the amount?
Yes, I am paying 10,000 amount. I am paying, but in another proceedings. And that challan, my lord, I have shown. I have filed before the learned.
When the order was passed on an application under section 24.
Yes.
Was this adjustment made?
Yes, that was my lord. There was,
that adjustment was made.
No, my lord. That's not the judgment, my lord. But it should be, my lord.
That is a different thing altogether. Till that is made, you are in default. Unless that is adjusted,
Lord,
you are in default.
That is why I made an application.
Show me the order passed under section 24. Which one is earlier? Section 24 earlier?
No,
125 is earlier.
125 earlier.
125. Show me the order under section
24.
24.
24 earlier, my lord. 24 earlier.
24 earlier.
Yes,
Show
my
me the order passed under section 24.
24 order taken NS করা আছে?
10.
না 10/3/2025 the impugned order. আচ্ছা 16 আছে কিনা দেখো। Madam,
What happened to your petition for adjustment?
Madam, that is my last page.
No. What happened? What order has been passed on your?
Madam, that is impugned order 10th day of March 2025.
Show me that it was rejected.
Yes.
Show me.
Yes, I have annexed. Today is fixed for further order.
Yes.
Both sides have filed Hajira. Today, one petition is filed by the petitioner, supported by affidavit, praying therein for adjusting the alimony pendente lite ordered in the miscase which had erupted out of the present suit, with the other amounts which the petitioner is paying to the respondent as maintenance allowance for alternate accommodation and monetary relief in other proceedings between the parties. He has further prayed for vacating the stay granted in this suit. As the instant petition pertains to the stay or granted by this court of the present matter, the said petition is now taken up for hearing and order. Learned advocate for the petitioner submitted as per his pair in the said petition filed on this day. Learned advocate for the respondent raised strong objection. Heard both sides, perused the petition and record considered. It is apparent from the said petition and the admission of the learned advocate for the petitioner that the arrears of the maintenance pendente right as ordered by this court by its
So your application for adjustment has not been disposed of by this order.
no, accordingly dismissed. Accordingly dismissed.
No, what is dismissed? Instant petition for vacating the stay cannot be considered.
Well,
and is dismissed.
that the order was written, but my peer is kindly see the petition on the next paragraph. Kindly see the petition. The monthly stop.
July. Yes, next.
In the meantime,
In the meantime, what?
Divert.
Stay will be vacated.
Well, kindly.
In the meantime, stay will be vacated.
Otherwise, may not. Parties are living.
Ultimate relief at the stage of admission. Thank you. Yes.
I love listening.
Mr. Shona Bhattacharya is happy. 19.
Item number 19. Yes.
Shona Bhattacharya is happy.
Since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Next.
For the petitioner.
Yes.
When I'm praying for an expeditious disposal of a eviction suit, my lord, the petitioner before your lordship is the father-in-law of the opposite party. My lord, the opposite party.
Father-in-law.
Yes, my lord.
So licensee eviction.
No, my lord. There was a ex parte decree of divorce. In spite of that, the opposite party is residing at the house of the petitioner, and they are constructing some construction matter over there. And that is why, my lord, they have in the month of May 2024, this eviction suit was filed by this petitioner. And my lord, till date, my lord, the summons has not been served upon the opposite
Then
party.
how can a direction for expeditious
My
hearing
lord,
be
in the
passed?
month of June, the next date has been fixed,
Yes.
my lord. Well, 1 year has been I'm praying for expeditious
Next.
yes, my lord, in the next
Yes,
also.
next.
I'm praying for expeditious.
Next is also same.
No, my lord, this is a mat suit which has been filed in the month of March 2024. Although the respondent
Madam,
appeared,
March 2024, only 1 year you are approaching for
my
expeditious.
lord, the respondent has appeared, but till date
Maybe.
they have not filed WS.
That is
On
a different
repeated
thing
occasion,
altogether.
They are repeated occasion, my lord, they are praying for time to file the written statement, my lord. And the next date has been fixed in the month of June 2025. 27th June, my lord. From the e-courts, I could gather that.
You are the husband.
Yes, my lord, I'm the husband. We are residing together separately since 2014 because the husband has left for USA, and my lord, on the desertion ground, I have filed this mat suit.
Any application, any miscellaneous case for alimony pendente has
My
been
lord, no, my
filed?
lord.
Any other proceedings for maintenance?
No, my lord. Nothing is pending.
This application under Article 227 of next. Yes,
22, my lord, I am appealing for the petition, my lord. I want, my lord, the direction for expeditious disposal. My lord, why it?
Chakravarti, you are
My lord, my lord,
expeditious hearing.
this is a, my lord, there is a reason. My lord, this would.
That is the reason you have to move.
My lord, why I say, my lord, 2016 suit. My lord,
allow the juniors to move expeditious hearing matters, Mr. Chakravarti.
No, no, my lord.
Why no?
Bol.
Yes. When have you been enrolled?
My lord, 2021.
2011. 2011.
Yes, my lord.
Yes. Yes.
My lord, I'm praying for.
What is the suit for?
My lord, the suit for is partition for suit for partition and declaration.
Who are you? The suit?
My lord, I am the plaintiff, my lord.
Yes. So
My
what
lord,
is the stage of the suit?
My lord, suit is now pending, my lord, one petition dated 4th August 2023 for ex parte against the defendants.
Yes.
My lord. And
4th of August.
Yes, my lord.
2023.
And my lord, I have filed. We have filed the.
What happened on 28th of March? It was fixed for hearing of the
My lord,
petition
28th of March, my lord, no hearing would be,
What is the adjourned date?
my
What is
lord,
the
the
next date?
6th June, my lord, next date is fixed for 6th June.
6th of June.
Yes, my lord, my lord.
Hearing of the petition dated 4th of August 2023.
4th of August 2023, as well as, my lord, we have filed the one receiver application for appointment of receiver dated 17th January 2024.
That has also been fixed.
That was also been fixed on 6th June.
All right. Thank you. Yes, Mr. Chakravarti. What is the
Milord-
extra point you want to add?
Milord, defendant Milord till today, Milord has not Milord submitted his written statement. Court is again and again
For
adjourned.
that, Mr.
Milord,
Chakravarti
we
take steps.
yes, Milord, we have taken steps, but that steps even not been heard out. Milord, the petition we have filed, Milord,
What is the next date fixed for filing of the written statement?
Milord,
What is the extended date?
extended it already passed, Milord, long ago.
No. What is the present date now? When they have been directed?
Milord, 6th of June is the next date. If you lordship kindly sees
For
the last,
filing of the
no,
statement also.
no, not for filing of written statement, only for Milord petition.
Now,
Milord,
what do you want?
in respect of defendant number three, it
You
is
want the written statement also to be filed within that date?
no, Milord, 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 the right they have lost. Milord, I just, Milord, beseeching your lordship, kindly passes an order, Milord, to dispose of those two petitions on that date. Otherwise,
Order 40 Rule 1 and
Milord,
what is
another expertise, Milord, petition, Milord, expertise proceeding, Milord, against defendant number 1A and 1C.
1A and 1C.
Yes,
So
because
this is the application filed by you for proceeding ex parte
My-
against
my-
defendant numbers?
defendant numbers 1A and 1C. Defendant number 2's written statement already accepted, 3 already.
1A and 1C.
1A and 1C.
Ashwin. This application under Article 2
38. Oh my gosh.
38, yes.
The application is for expeditious hearing in connection with final decree proceedings in partition suit of Title Suit 2000.
That was the expeditious hearing.
Pardon?
Direction for expeditious hearing passed.
Suit filed in the year
Mr.
2011.
Ganguly, can you use the mic? Please help.
Suit filed in the year 2011, my lord.
Yes.
And preliminary decree,
What happened after this order?
nothing, 4th June, next date, nothing is being done.
Then, Mr. Ganguly, it's better you serve and come back. Otherwise,
If you lordship direct,
that was the direction, Mr. Ganguly. It's better.
yes,
If I direct you to serve, let them come.
they are not appearing, that is the whole difficulty.
They are not appearing in this.
No, my lord.
also.
Expertise decree should.
But the commissioner's report has not yet been received.
I am on instruction and submitting the commissioner of 3 districts, nothing is being done. Kindly direct any.
The commissioner has been appointed.
Appointed.
So, what happened? Writ has been issued in his favor.
But nothing is being done. He is not holding the commission. Kindly see, he is not holding the commission.
What can be done, Mr. Ganguly? That is the practical.
Kindly direct the landed district judge, if it pleases your lordship, to appoint any commissioner from any district, my lord. The matter has to be brought to a logical conclusion. Preliminary decree, page 23, kindly see.
No, page 23 is the temporary injunction.
No.
Preliminary decree is, I think, page 28.
28, my lord. Sorry, I'm sorry.
Yes, sir. What is the
Lordship,
date
pardon
of
me.
the preliminary decree? What is the date of the preliminary decree? Because that copy is not very legible.
13th June 28.
13th of
June.
13th of June 2018.
Yes, my lord. Yes, my lord.
This application
24.
But I am for the petitioner. My lord, impugned order is from final order of a section 24 application for alimony pendente lite suit filed for by the husband. In the affidavit of assets, I had declared I had income of 15,000. There is a child who is going to school, not a penny till date paid. The husband admitted 1 lakh rupees per month he is earning. He admitted that he has a Godi in Borobajar from where the proprietorship business earns 1.5 to 2 crores. He did not submit any bank documents regarding that. The order is at page 232. The learned trial judge has given 5,000 to the wife, 20,000 to the daughter. The daughter is going to a school which she has already incurred 45,000 expenses.
Where is the finding of the income of the husband in the impugned order?
Yes. Kindly comes to page 235.
Tell me the internal page of the impugned order.
Page 4.
Yes.
Page 4, my lord, 1, 2, 3, 4, 5, 6, 7, 8. 9th line from the top. All these aspects.
On swearing affidavit, he has said.
Yes. Admitted position. In the affidavit of assets, he has said 1 lakh is my income. He has also said I am the proprietorship owner of a proprietorship firm. From gross amount of that firm is 1.5 to 2 crores per year, the gross volume of business.
Gross volume of business is one thing, income is another thing.
Well, at 50% I will hold, 75 lakhs.
50% is
50% would be profit. 25% profit.
Is it so?
25. Well,
50% will be the profit of the turnover.
Well, he has not annexed it.
Do you have any? You are saying
he has not annexed the profit and loss accounts. Well, that's what I am saying.
That is a different thing altogether. Yes. You are saying the 50% will be the profit of the turnover. What are you saying?
Very well, Malad considers 1 lakh. That should be at
least. Now on online, so there will be an immediate amendment in the Income Tax Act.
Do we have
on furnishing of these documents, they can assess. So if they hear your this submission, then there will be an amendment in the.
Do we have to declare 50% that is our income in the income tax? And the lawyers now have to declare that 50%, what is the gross amount, 50% is the income. 50% is deducted, but 50% up to 25 lakhs. Yes. My lord, may I just make no.
Well, I'm for the petitioner, my lord.
Yes, please for the opposite party.
Well, we have served. No, we have served.
My lord, we have served, we have also contacted over phone.
Where are they?
My lord, will kindly see the email.
I appreciate that. Mr. Chatterjee, it's one day, so I'm keeping it on Tuesday. Because some time is to be given.
My
Though you have served, but they are not appearing.
My lord will only
because time is too short.
I understand that, my lord, but the problem, my problem, my lord, if I can secure their interest.
It on Tuesday.
Well, I'm not seeking any adversarial order. My lord, my prayer is the account be decreased. I am putting in the security.
May I say this, my lord? May I say this? Well, what happens is they have, my lord, attached several accounts. Those accounts, my lord, if your lordship adds up the amount of money that's there, my lord, it's about 8 lakhs. I am giving your lordship today an account which has 24 lakhs. So their interest is.
I will pass that order. I'm keeping it on Tuesday as for orders. Tuesday or Wednesday as for orders.
I have to pay the salary by today or tomorrow because today is 2nd. My salary goes from that account.
I can keep it at 2 p.m. if you can bring them. Otherwise, it has to be. Because Mr. Chatterjee, you understand.
I understand. There's a practical difficulty both sides. This is the problem.
Both sides, or I can fix it on Wednesday.
We shall take a chance at 2 p.m. in that case.
We have we'll again try and contact them, my lord, if they can come at 2.
Not yes.
Well, I will contacted.
Not contacting, bringing them.
Because the person indicated he is bedridden, but he has informed his advocate. The advocate will be present. This is
then Mr. Chatterjee, it might be difficult if the person is bedridden.
No, he can contact the lawyer who is going to come.
Over telephone, some instructions. I think Chatterjee, it's better it's on Wednesday. Because he will come and say, I need to take instructions. Because
keep it on Tuesday then. Tuesday.
So I think some time has to be given.
Keep it on Tuesday.
Learned advocate appearing for the petitioner submits that the order and directions contained in the order dated 1st of May 2025 has been complied with, and an affidavit of service has been filed in court today. First up, Mr. Chatterjee, learned senior advocate appearing for the petitioner on instruction submits that the one learned advocate contacted the learned advocate on.
We have the advocate for the petitioner has contacted the opposite party, and the opposite party has communicated this. The person,
the advocate has not communicated. No advocate has communicated.
No.
So the petitioner has communicated to the party.
No advocate of the opposite party.
No.
Has complied, and the affidavit service has been filed. First up, since the direction to serve was passed only on 1st of May 2025, this court is of the view that some more time should be granted to the opposite party to represent themselves, to represent himself before this court. First up, in view thereof, list this matter under the heading for orders next Wednesday.
No, Tuesday, my lord.
Tuesday, Mr. Chatterjee, now I have decided for orders will be on a particular day. That is why I'm keeping it on Wednesday.
But it will have some precedence, my lord.
For orders. If you want some more precedence, it can be somewhere above.
Well, I was on a lighter note hearing the last matter, my lord. The learned lawyer did not know, my lord, that your lordship was an income tax specialist.
Yes, next.
For the petitioner loss.
Yes. Mr. Ghosh, you are opposing. You have got the copy. Yes.
Yes, submit the affidavit of service.
Yes.
Now, see, this application, while my police help was rejected.
Your police help application was rejected? On what ground?
That saying that it was not filed within time. It is the ground. That is different. Lordship, when I already they have challenged this degree.
it was, they have preferred an appeal. In that case, they have not obtained.
So those who have brought that
application.
judgment, that
I have not got it, but your lordship knows that that's why I have. Your lordship, your lordship, your lordship can see at page 80, there is mention. And
page 80.
80. And your the degree, that is at page 33, your operative part of the judgment.
Decrease at page
Degree at page 33, Lord.
33.
Yes. Pages are not there. Over
No, counterclaim is dismissed and the decree is
degree of 33 that order.
a decree for permanent injunction. And what is the execution application?
At page 80.
Yes, why it is not maintainable? It's
Order 32. Permanent injunction, it can be executed. What is
yes, order 21 rule 32.
yes? That is by not being this form.
Attachment, detention in civil prison.
It has no limitation block anytime. And if it is transferred, then one judgment was verified by justice. Dipankar Gat to increase trust.
Yes, sir. How is that execution application maintainable? Under order 21 rule 32.
This is a scheduled property where in against that property that the permanent injunction was granted.
How it is to be executed?
That
It's under order 21 rule 32 by way of attachment and by putting him to put Mr. Ghosh's client to prison. Put him to prison. But how can that be with police help?
No, police help is that the particular area of under my possession that is not be able to be granted to the judgment debtors. That is the question. Lordship kindly consider that this particular portion will not be entitled for them. Only I am entitled. I have given a gift. That was I am entitled, and they have specific entrance for using their portion. I restrain them for using my portion. There is the specific direction already as passed by the learned court below.
But how do you come over this limitation part?
Lordship, initially
application was filed on 6 April 2020.
Yes. A limitation act.
only 6th
Limitation
July.
act আছে, limitation act.
Order of the 6th July 23 is page 88.
Yes.
That is the
No, the resistance was on 17th of June 2023. When did you file this application?
that I am telling you. After that, during that period, the appeal was pending.
I'm asking you, when did you file this application?
On November 23rd.
Yes. November? Yes. Article 129. 30 days from the date of resistance.
There is the provision, but I am coming, Lordship. Why I have filed this application?
Yes.
Initially on the, Lordship, kindly come to page 89, the last portion. I am not inclined to stay the execution proceedings as a whole, but only to the order of executing court for issuance of writ of delivery of possession dated
No, that is,
1993.
yes,
That time, one of the or direction was referred for
no, no.
stay
Yes, stayed on,
for issuing the writ.
yes,
That has
but thereafter writ was issued. Writ was issued, they went there and possession was sought to be taken, resisted. Then this application for police help has to be filed within 30 days.
that I am coming, Your Lordship.
Sir, who is behind you? He is nodding his head. Who is he?
No, he is the son of the petitioner. I
Please ask him to sit there. Yes.
That police help was filed in the through the application, Lordship. That is on 17th November 23.
17th of November
23.
No, the court records 6th of January 2024, you have filed this application.
It was sometimes a mistake, but Lordship kindly go through the order.
What is the mistake? The trial court's, the executing court's order is mistake.
No, date, only date. Lordship,
Yes.
I'm explaining, Lordship.
Even if it is accepted on 17th of November, even there it's 30 days beyond.
Why I was not able to file that the resistance from the judgment debtors was happened in several times. Lordship, in that sense, I can submit only one judgment, Lordship. This is reported in AIR 1984. Police help is something special for, there is no requirement for time. Paragraph 2 and 3 and 4.
Where is your application for police help?
That is 94, 95 is the
Page?
Page 94.
Yes. Yes, Mr. Ghosh, what do you say to this judgment? Have you seen this? You have another copy. Please give it to him.
So this judgment supports the other judgment, Garnath Ghosh versus Amulya Chandra Sarkar. That is also reported in AIR 1957, Calcutta 252.
So, Ghosh, do you have a copy of the civil rules and orders? Yes, what do you say to this judgment?
What has been under this year in view of the
Application is captioned as one under section, and here it says, so if it is not under order 21 rule 97, but it is 208, then that limitation will not apply. That is this decision.
What is the contents of the application?
Yes.
Act law, it is resistance, the execution. Shareholder law is different. That when
That is why I want to see that.
and not that about when the execution case itself is not maintainable in view of the provision of order 21 rule 32. Question of right. We are not in case of
No, there are two things, Mr. Ghosh. There are two things. One is this application was rejected on the ground of limitation. So that is one part. If you say no, if it is held, it was within limitation, then for merits, what you are saying that it is could not have been in that, that has to be decided in that line. That is one thing. And yes, sir, what do you say to this, that whether this type of a decree could be executed in the form in which you are trying to execute?
But I am trying to execute lawsuit that the scheduled property, that is, which is.
Sir, can it be, how if such a decree, your decree is this, kindly come to page 35. This is the decree which you have got, ordering part. So how this type of decree is to be executed? What is the provision of law? Under what provision this type of a decree is to be executed? Under what provision of law?
That they are trying to embrace and embrace. They are.
Sir, I'm asking you under, I know what is the obstruction they are creating. My question to you is, under what provision of the Civil Procedure Code such a decree will be executed? Under what provision? Then I have to test whether your execution application is maintainable in the eye of law or not. Under what provision? Please tell me the provision first, not the facts.
Order 32 rule 5. That is
Order 32 rule 5.
Order 21
Rule 32. Order 21 rule 32.
32.
Yes, place order 21 rule 32.
And sub-rule 5, lordship, where a degree for specific performance of a contract or for an injunction has not been obeyed, court may in view or in addition to all or any of the process aforesaid direct that the act required to be done may be done so far as practicable by the degree holder or some other person appointed. The expense occurred may be ascertained in such manner as the court may direct and may be recovered as if they were included in the decree.
Yes.
In that sense, I have obtained the injunction order.
So, permanent injunction. So, according to you, order 21, rule 32, sub rule 5.
Lordship. So, I have obtained this order. Thereafter, I am trying to resist the judgment letters. So, my position will be clear in that sense.
Yes. Anything more?
This is from my side, and also while the judgment letter filed this appeal, in their case there was no specific direction. One of the direction passed. Lordship, kindly come to.
Yes.
That is all. Page 43 start with the order 2nd June 2023. Page 43 and the relevant part of page 45. The balance of convenience and inconvenience, also the subject matter while deciding a prayer for temporary injunction, it is alleged that appellants are using.
No, this is the appeal filed by them. No. Yes, what happened to the appeal?
Now appeal is pending. They have not obtained the stay order. Only the stay was granted for a limited part. So that I was entitled to file this
Execution.
application for order 200 days.
Yes, Mr. Ghosh, what do you say? Order 22, rule 30, order 21, rule 32, sub rule 5. In lieu of also that. So he has a choice. If he has a choice, if he has availed of one of the remedies available, can you say no, he has to pay for attachment?
I am not in possession. His allegation is that I am.
No, there are two aspects, but this issue has not been considered by the executive court. The first part is what do you say to the limitation? Because as from this judgment, since it has been captioned as one under CRO.
Here caption will not be your lordship is substance. Substance of this act.
Where is the CRO? You have not brought that.
Right.
Threatened injury, there are some.
But they are not at the very initial stage of execution. If it appears that the circumstances is as such that without police help can be executed, then along with the execution application, CRO is filed.
That is the exceptional circumstances. According to you, it's not a regular method of police help.
Yes.
So
Their case is that bailiff approached, bailiff was arrested, bailiff submitted a report. Long thereafter, they filed the application. By caption, 200 days. But it is in fact an application under order 297.
but what the bailiff will do? What the bailiff will do?
No, bailiff has nothing to do. Bailiff has been registered. This is fact, this has been proved.
Bailiff, what the bailiff will do? It's not a decree for recovery of possession.
Yes, bailiff has nothing to do.
Bailiff has, even if the bailiff goes through police help, that's a different thing altogether. He can approach for police help. It's whether the police can be posted there for all times, 24/7 into 365. That has to be decided under what condition. So it's not a decree for recovery of possession that the bailiff will go and deliver possession.
In spite of injunction. His only remedy, Lord, order 21 rule 32, either attachment of property, then
No, but
attachment to
that is, but the order 21 rule 32 sub rule 5. So how far that will be applicable in this? That is what you have to say. And
your nature of the decree, that is also not a.
but first is the limitation. What do you say to this? It's against you, apparently.
Judgment.
That is, Mr. Ghosh, that has not been decided. That has not been decided. It has been rejected only on the ground of limitation. Then I can restore it, set it aside that relying on this, it is 208. So I am relegating to the executing court to decide that. You will be entitled to raise all points with regard to the objection and other things. This application under Article 227 of
That's
The prayer of the learned advocate for the petitioner hearing.
Execution. Well, a suit of the year 2005, judgment was passed in the year 2009. Appeal has been, my lord.
You are not challenging any order.
No. Appeal has been also been dismissed, my lord, on 7th of February 2024 without contest.
This application under Article 227.
For that is been kept pending.
On the next matter.
But that application be disposed of on the next.
What application?
Fresh writ of execution through bailiff. We have filed.
Execution case provided there is no stay.
Right.
I've said. Yes, next.
29.
29.
29 for the defendant petitioner.
Yes.
The landlord plaintiff filed a suit for eviction against the defendant.
What is the impugned order?
Impugned order 7-1 and 7-2 application dismissed along in a single order.
What is the ground of rejection?
That I could not deposit the area rent without determine the landlord tenant relationship because the father of the plaintiff filed.
You have raised the issue of.
Yes.
What is the issue? What is the dispute of landlord tenant
Yes, my lord,
relationship?
because I raised that the.
Who was your inducting landlord?
Yes, my lord. Kindly come to.
I'm asking you. Say who was your inducting landlord?
The father of the plaintiff.
The father of the plaintiff. Father died.
Yeah, that, my lord.
So now you are challenging that there is no relationship.
No, my lord, that is not. But the file.
All right. So you contest on the ground of relationship. You disprove that, suit will be dismissed. No issues on that.
No, my lord, the point is that the father will die.
Not a bona fide.
No, we came to know that the father died in the shoot, my lord.
Yes.
Because there are previously they refused to take the rent. We deposit.
It's a suit under the 1997 Act.
Yes, my lord.
1997 Act. Landlord may be even a person who is not the owner of the property.
But the relationship should be proved. And there is a question regarding the area rents. As per my calculation, there is no area rent. The area rent should be calculated in the 7-2 application, my lord.
Did you admit the? Did you pay the admitted areas?
I paid the rent control. Rent control.
Rent control till which date?
Till date.
Till date.
Because
in whose name?
In the name of the father of the plaintiff.
He has died.
No, but this come to know in the application.
Maybe, so when you came to know, it's your choice, but it's invalid.
No, well,
Those deposits are invalid.
but this should be decided in the.
When the, no, all disputes, frivolous disputes need not be decided.
One judgment, my lord.
So you have a choice.
No, there is a judgment regarding the, my lord, by coordinate bench, my lord, in CO 2837, where the landlord-tenant relationship should be proved.
Yes, yes, not every dispute, it should be a bona fide dispute.
Yes, sir.
Show me that it's a bona fide dispute. That is why I'm asking you. Father was the landlord. After the death of the father,
Yes,
you are raising a dispute that the son will not be the
No, my
landlord.
lord, kindly come to pay their plaint.
Please show me those judgments where it has been said that the only a bona fide dispute is to be decided.
The bona fide is that the plaintiff, in their
Bring
plaint,
those line of these judgments.
yes, in his plaint, the plaintiff stated that he inducted me as a tenant. But this is a false. The father of the plaintiff inducted me as a tenant, and there was a agreement between the father and the tenant, defendant plaintiff, my lord. Kindly come to page 12, my lord.
Where is your application under section 7.2?
Yes, my lord. Kindly come to page 20, page 34, my lord. In paragraph 2,
Paragraph
2. And in his plaint, my lord, in the first paragraph, he stated that he inducted me as a tenant. But the agreement between the landlord and tenant speaks different, my lord. And the rent also be disputed because he told that that 120, but as per my calculation, it is 350, and I deposited rupees 350 till date, my lord.
Please come to paragraph 4. You have admitted the relationship with the plaintiff. You have remitted rent to whom? After the death, you approached whom?
Yes, my lord.
For payment.
Addressing to the plaintiff and one Pratika Chakraborty.
Yes. First sentence.
That the plaintiff refused to accept the.
Yes. So, did you approach both at the time of tendering?
So may I adjourn this?
Right. No adjournment.
No. As per my knowledge, my lord,
From the petition.
No.
From the petition, you have approached one.
I approached.
Now you have made out a case that yes,
No, my lord.
at the time of deposit, the son and the daughter both.
I approached both of them.
Where have you said it that?
May I show one rent control receipt that I approached both of them, my lord?
Mere deposit before the rent controller does not prove the landlord-tenant relationship. There is a reported judgment. So you may deposit in whosoever name you may think, that does not prove the existence of landlord and tenant.
But the 7-1, my lord.
7-1, you have said that you approached plaintiff and he refused. So you ought to have deposited in the name of the plaintiff before the rent controller. You can make those submissions. Yes.
My lord, in his judgment, my lord.
Sir, it's very easy to dispute the landlord-tenant relationship.
No, it isn't.
By making one line is disputed. It's very difficult to come out of that. And you can succeed. What will happen? Nothing will happen. Your defense will be struck off, but you are sure that there exists no relationship. Prove that fact, suit will be dismissed. You need not pay, sir. If there is no landlord-tenant relationship, suit will be dismissed.
Now, only and another
can evict you, sir.
No, and another thing is, but it is
what do you want now?
Arguable in the.
What do you want now?
My lord, kindly adjourn the 7-1.
After some argument, the learned advocate appearing for the petitioner prays for an adjournment. So, sir, in view thereof, the hearing of the matter stands adjourned. Yes, take back the judgment, place it at the appropriate point of time, and also come with those judgments. Yes.
Yes, my lord.
Next, call the next matter.
Fair. My lord, this is my review petition, revision petition.
Say so. You are started with review
My,
petition. I was
my
asking,
apologies.
what error I have committed?
My lord, I'm led by Mr. Ratnanko Banerjee in this matter. He's in Delhi today, so my prayer was to seek a nod today, and if your lordship could take this matter up on Monday.
And my prayer to him,
Not today is accepted, but
my prayer
It
to
will be
him,
fixed for Monday, your lordship.
I have been telling him, please get whoever is between you and Mr. Banerjee so that I can oppose the prayer for adjournment. I can't oppose his prayer, but this is a matter which is, my lord, strange situation where, my lord, I normally never oppose. Last time they paid 3.5 lakhs cost in this court. And thereafter they're again playing truant. My lord, may I just tell your
My lord,
lordship the problem?
It's on a different issue altogether. I'll demonstrate that
it's
to your
not.
lordship. But
what,
I was
what
just
should
seeking
I,
a
my lord, I have a
impugned order.
impugned order is rejection of right to file, amend the written statement. After conclusion of trial and after final arguments are completed from my side, totally malafide application for amendment. After, my lord, they kept on delaying and this honorable court imposed 3.5 lakhs cost on them and said finish the matter. Then they go file application for amendment.
My lord,
That's been dismissed up to, my lord, DRET.
my lord,
Now they have come.
my lord,
Yes.
the impugned order is in respect of an order passed by the Learned Debts Recovery Appellate Tribunal, upholding the order passed by the Debts Recovery Tribunal, where my right to amend my written statement has been forfeited. And the earlier round of litigation, which was in relation to the same issue,
Not a case where I will force him to.
my lord,
My lord, would your
my
lordship
lord, I'll show it
permit,
from
my
the
lord-
correspondences.
Would your lordship permit it to be taken up as the first matter on Monday as a, my lord, 100 crores outstanding, we are, my lord, in deep difficulty. I understand my learned friend's predicament, my lord, I can't force him to do this matter.
My lord kindly keeps it on Monday, but it's a 35 crore claim against me.
Yes, with
And
interest it's 100.
the written statement amendment that's been brought about as no new case that's been formulated. We are just amplifying our defense. There was certain material. My lord kindly keeps it on Monday.
চুপ করে থাক।
Where is your application for amendment?
My lord, the application for amendment is annexed,
92.
page 92, your lordship.
92.
Yes. My lord, and if your lordship sees page 98, there is also a schedule that's been given for the proposed amendment, which is sought to be incorporated
Yes,
into the
where
written
is that?
statement.
Page 98.
Page 98, your lordship. If your lordship takes page 98, there's a schedule of amendment right at the top.
The schedule of amendment is runs to almost 11 or 12 pages.
My lord, the documents on record, which
For at least 5 lakh rupees cost because last time
My lord,
we paid 3.5.
my lord,
My lord, one request, my lord.
there was a, my lord, even the conduct.
At 2 p.m. on Monday or my lord, please, my lord, normally I
No,
never.
Fixing the time.
My lord, kindly let it.
My lord, I'll tell your lordship what they've been doing.
On the prayer.
No, my lord, only one request, my lord. My lord, what is happening?
Totally, there will be no stay.
No, because despite no stay, the DRT doesn't take up the matter.
That is your choice.
No, that is not my choice.
Yes,
My
Mr.
lord-
Chaudhary, your pendency of a civil revision application does not.
No, but this way they haven't done final hearing for 1 year.
My lord,
Despite orders of court.
The DRT was not in session for 1.5 years and then again
24th of April
No,
2025.
because of pendency, may I show? Just
My lord,
let me show your
my
lordship.
lord,
the
that
list.
evidence has been filed 3.5 years after they have lodged their claim, which was in 2016 November.
Please just see the list of it.
And
I can't assist my learned friend more. Please see, my lord, what has happened. My lord, 24th November 2016.
No, now it's the matter is pending before the DRT now.
Yes, sir.
After this rejection of this
Jackie
appeal.
will not move.
Last order.
He will take 5 adjournments.
My lord, that's the whole
No,
crux
that's
of the
not
matter.
forgery.
My lord, the
That
crux
for you to apprise the
No, but it is
judge,
also my right to
my
get
lord,
this dismissed.
my lord, the crux of the matter is
Also
the
last order.
Post filing.
the order from the last civil revision has been misinterpreted. They are seeking for a clarification from the Honorable High Court that if amendment to written statement can be allowed. Whereas the earlier civil revision that was preferred, your lordship, that was on the question of filing evidence.
the learned advocate.
Service be brought on record.
The matter will come tomorrow.
Tomorrow, if you want, it can be done.
Yes, yes, I don't.
My lord,
Yes.
we'll be
We
taking
can
some
come tomorrow.
My lord, we'll be
Yes.
taking some time with the matter on Monday because we'll be showing a couple of documents and
So it
orders.
has been adjourned. Let's see what happens.
Milord,
Very well, your lord.
Milord, may it retain its position in the list. It will go down, Milord.
Yes, call the next matter.
I'm grateful, and I'm also grateful to my learned friend for allowing the.
After that, you should not say anything.
Milord, if it
Yes, yes, call the next matter.
I'm for the petitioner, your lordship. I'm praying for not today. I'm being led by Mr. Jain in the matter.
On the prayer of the learned advocate for the
32. My revisional application directed against an order passed by the learned commercial court at Rajarhat. But will find the impugned order at page 54, whereby I had filed a section application under section 151 of the Code of Civil Procedure, praying for attachment and injunction upon the property. Well, it's a money suit, and the subject matter involved in the suit was being sold or trying to the defendant was trying to sell off the property. Malad will kindly see the learned judge has recorded all my submissions and the documents which I have placed with respect to my prayer for injunction and attachment. I will kindly take internal page 3, that is running page 56 of the order. Well, may I place it?
Yes. No, you need not place. Let me go through this.
Well, may I just
Is it not an appellable order? Prayer for injunction was rejected.
Yes, your lordship.
So an appeal lies.
No, it's a 151 application.
Maybe, but it is in effect order 39 rule 1 and 2.
That will kindly take the Code of Civil Procedure works.
Yes.
Well, in that case, if your lordship kindly takes up, I am being hit by section 3 of the Commercial Codes Act.
Yes.
Well, section 3 of the Commercial Codes Act, my lord, will kindly take once.
Section 3, yes.
It's not section 3, my lord, section 30. At my place, appeal. I have a copy of that.
Yes. Yes.
Well, I will kindly see section 13 of the Commercial Codes Act.
Yes.
Appeal from decree of commercial court or commercial division.
Yes.
Any person aggrieved by a judgment or order of the commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. Any person aggrieved by the judgment or order of the commercial court at the level of a district judge exercising civil original jurisdiction, or as the case may be commercial division of the High Court, may appeal to the commercial appellate division of the High Court within a period of 60 days from date.
Yes.
Provided, will kindly take the proviso that an appeal shall lie from an order passed by the commercial division or commercial court that are specifically enumerated under order.
No, what I've said, provided that an appeal shall lie from such orders. From such, but you have read
Such
something
orders.
different.
Provided that an appeal shall lie from such orders.
Yes.
Passed by the commercial division or commercial court that are specifically enumerated under order 43 of the Code of Civil Procedure 19.
Yes, order 43, it comes under order 43. Rule 1, sub rule R. Though you have captioned is as under 151, but the injunction has to be under the by invoking the powers under order 39 rule 1 and 2. Caption is your choice, but what is the substance? You have prayed for an order of injunction.
Injunction, my lord, and attachment also.
Attachment is a different thing. Injunction is refusal. If you want to challenge the injunction refusal, it's an appellable order. Though you have captioned it as 1 under 151, but it is in effect exercising powers under order 39 rule 1 and 2.
Well, in that event, may I come back on Tuesday, your lordship? I am led by Mr. Sengupta, my lord. Subhashish Sengupta.
On the prayer, after some argument, the learned
Well, this is my application.
Yes.
Well, this is the application against order 1, applicant for order 1, rule 10(2). What's happened, my lord? Three brothers.
Order 1, rule 10(2), rejected or allowed?
Rejected.
Rejected. What is the suit for?
Suit for eviction, my lord. There are three brothers of the plaintiff.
Suit for eviction, whom do you want to add?
Well, the thing is that the plaintiff number 2 died.
Yes.
Other plaintiffs expunge his name. We are the intending plaintiffs who are the legal heirs of the plaintiff number 2. So when we came to know regarding the suit is pending, and
you are the heirs of the plaintiff number 2.
Other plaintiffs expunged my father's name. After knowing the fact, we applied order 1 rule 10(2) as a necessary party, as because
by the yes.
the expeditious hearing mala 2013 mamla. I am for defendant petitioner mala. So for partition injunction mala for adverse position 2013 matter. Next date mala
This application, so injunction application is pending.
My lord, till now.
This application under Article 227.
Item 35, I beg to differ for the opposite. The trial is complete within 1 month.
Let the implementary applications be disposed of
My lord,
first.
all petitioner are senior citizen, my lord.
Yes.
My lord, I beg to appear for the opposite party, my lord. I'm on caveat, my lord. I'm just seeking for a day's accommodation, my lord.
Yes, my lord.
I've been led by Mr. Shanton Basu.
It's not only yesterday, my lord, only. My lord.
I'm just led by Mr.
You
Basu.
have started only yesterday.
Yes, my lord. Just days accommodation.
The learned advocate appearing for the caveator opposite party submits that a copy of such revision application was served upon him only yesterday. बोले कल के डेटा दे देवें. In view thereof, hearing of the matter stand.
Lord, I am appearing for the corporation.
I am for the petitioner lordship. Kindly make it not today.
Kindly, my lord, the difficulty is your lordship will kindly appreciate. I am very sorry to submit. My lord, no order is there. The order of demolition has been affirmed up to building tribunal. Then, my lord, a suit has been filed in 2025 where no injunction is there. Now, because of this, my lord, since there is no direction upon the police, the corporation peoples are going on, my lord, and coming back, my lord.
Where is Mr. Sannal?
He is already left the court because of some.
All right, so I am clarifying that since there is no stay, the corporation will be at liberty to take steps.
We are taking
Due to the medical emergency, he already left
we
the
have
court.
given my lord on 9th
Due to
of
the
April.
medical emergency, he left the court.
Due to medical emergency,
Yes,
who has
yes,
left the court?
Mr. Shobananda Shanal.
On 17th of February, also a similar prayer was made.
And,
It was also adjourned 17th of February.
Actually, the matter was mentioned without giving notice.
No, we have
Who
not
mentioned?
We have not mentioned. But
Who mentioned is appearing in the list of who mentioned? What are you saying? Nobody mentioned this. This was appearing in the list.
Pardon me, lordship.
Were you instructed to submit that this was mentioned? It's appearing in the list under the heading listed motions. Why are you making those submissions without having any instructions?
There is some
in that regard?
miscommunication, lordship, from my side.
The last occasion also they took time, my lord.
Yes, yes, that is why.
Without implementing a such party. My lord.
Kindly make it not to the lordship. Kindly.
I filed this application, as a result of which I have filed an application for addition of party.
You have filed one application for addition of party.
We are making complaint from the
When this matter
Passed an order on 23rd, my lord, and directed to serve, but I have served and they have received upon the learned advocate of the in the lower court and also.
You are appearing, yes.
My lord, this is my every service, my lord. That here the 75 years old defendant, my lord, to short time on 2 occasions. My lord, before that, my lord, the cross examination was done of the PW1, and diligently, my lord, the cross examination was followed. My lord,
So evidence was closed.
Evidence was closed. My lord, 75 years, Lordji, my lord.
Come at 2 p.m.
My lord.
এটা দুটোর সময় তাপানো
Sole defendant, the petitioner before your lordship, she is 75 years old already. May I just place 2 or 3 orders? Admitted the adjournment was taken. Order number 37. May I start from? Order number 37. Order dated 31st January 2024. Has his lordship got it? The cross-examination of the PW closed. I attended before that. Prior to that, the cross-examination was done. Then next occasion, 9/4.
Examination, PW1 is examined
And closed.
Yes.
Thereafter, on the next date, 9/4/2024, I prayed for adjournment. Admitted. There is no debate. That must be candid. The next date, the PO was on leave. Till date, that PO was on leave, but also I filed application for adjournment because the defendant was ill. And then on the next occasion, since I have sought 5 time on the last 2 occasions, my defense evidence was closed. But immediately thereafter, I took steps for recalling of that order. But the defendant, I have.
So you prayed for time.
August also, that August 9th.
What happened? 31st of
21st of August 2024. The defense evidence was which is the order impugned herein. Immediately thereafter, I filed an application that I wanted to file the application for recalling of the order, but because of the illness, she fell ill. Medical certificate also.
On 3rd of October, you prayed for an adjournment.
Because they kindly see the medical certificate. She fell ill, 75 years old already. She could not come to the court. I filed the application, and the application is also annexed that she could not come to affirm the affidavit. That's why immediately I could not take steps. But
where is
thereafter,
the application? Where is your
that is page 10 and 11 is the medical certificate. 11 is the medical certificate. Pain and left falling injury following fall. So she was almost confined to her house. That's why immediately
give evidence. She will give evidence.
She only I take only half an hour only. This medical.
This is the medical document. Where is your application?
The application is just prior to that. Page 10. Typed copy, handwritten copy is page 9. Yes,
page 10 is the medical document.
Prior to that page.
Page 9A.
First annexure and the typed copy is also there. The typed copy may I read? Today's date fixed for argument since on the last occasion due to rejection of time petition on the ground of illness of defendant DW was closed. Today, the learned advocate of the defendant wanted to file a petition for recalling of the order, but since the defendant is ill, as well as the learned advocate of the defendant, the advocate record is also not cardiac patient. He is also unwell, for which he could not come to the court. As such, the application cannot be filed today for the ends of justice. Adjournment was sought. Immediately after filing the revision application, I filed the application also before the trial court that the matter is pending. Kindly give me some time so that I can pursue the matter to be listed. Thereafter, these 3 applications were filed before the learned court. These 3 applications were filed. I am humbly praying kindly consider sympathetically. I have cross-examined in details. Kindly permit me just for half an hour. Heaven will not fall. Prior to the next date, any day subject to your lordship. Fix that date. Definitely she will come and give the evidence.
What do you say? What is the suit for?
Suit for eviction.
As a trespasser.
No, there is suppression in the why I am I required to produce evidence because in the plaint the original tenant's name is not there. So there is suppression of other suits also. That evidence also I have filed. Kindly see. No. There is a judgment, recent Supreme Court judgment. Your Lordship knows it. 2G has not got retrospective operation. Prior to that, coming into 2G, if the original tenant dies, that 2G is not application, not applied. Kindly see the evidence at page 18. Just one line. This is why I am required to.
Yes.
I'll take your Lordship.
And 75 years slowly, that's why.
Portions of the order sheet. I will show you, Lordship, 2-3 pages prior to that.
No, I saw that adjournment, definitely.
21. The entire order sheet.
Look, I appreciate that, but fact remains that aged lady, there is a medical document, so I will put them to terms. So what is the next date fixed?
Next date I have given, but next.
So you have to cross-examine also the plaintiff's witness.
No. Only
not cross-examine.
Not at all. Only half an hour, my lord.
So only will need evidence.
Yes.
The law has been settled down by the Supreme Court. 3 times she can pray for adjournment. She has prayed for adjournment at least 7 times. Kindly looks at the conduct. She could have prayed for a petition.
I appreciate that. I'm fixing what is the next date. I'm
That,
fixing one day on
till-
that date.
Till the end of May, the stay is orders there, when I put up petition and the.
What is the next date fixed?
7th July.
For judgment, because
7th of July.
Any day, not any days, half an hour just, not positively, not I will attend.
that even I'm for the opposite party. I have served a notice on the petitioner yesterday, my lord.
130. Yes.
My lord, I am appearing in this matter. I am for the petitioner. Your lordship will kindly see, my lord, the bank, how they have committed fraud. My lord, kindly, it is very much clear. If your lordship will kindly see, that means that page 65, kindly take a look. Kindly, my lord, page 65. My lord, it is their self-admission, 10,71,000 rupees term loan is.
Page 65.
Page 65, Annex D.
Yes.
My lord, there is clear 10,71,000. There is no dispute. It is their paper. Now kindly have a look, my lord. Kindly page 68.
68.
Kindly, 68. Another means banks, another paper. My lord, there it appears loan is 10,99,000. This is the entire problem, and my property is going to be sold and is under auction, and they are taking police help. They have admitted before your lordship that they will, with the help of the police, will take. Though my lord, your lordship has requested that not to do because it is the hotbed of this judicial system. My lord, kindly, my lord, if they are in if they are saying that it is 10,71,000 in 9,000. We have paid everything, 10,71,000.
Yes.
My lord, we have two papers. My juniors are there. Is there, my lord? If it is 10,71,000, my lord, we have completed all. Whatever maybe, if there is any due, my lord, we are ready to pay here and now. If your lordship will direct us, but my lord, they are trying in this way and manner, and the learned DRT has not taken note of all these things.
Yes. Yes.
How this can differ?
Yes.
10,71,000, 10,99.
Yes.
And my lord, CS report is with my junior, my lord. If your lordship will say, then my lord, I will file it on supplement. I will be returning, my lord, and then my lord, that I will do. But my lord, that the only this question comes. My lord.
Yes. Please see the order impugned. What is the order you are challenging?
My lord, your lordship will kindly see the order impugned. My lord, my junior is, my lord, that is showing it there because I am actually your lordship.
Yes.
Yes.
Yes. What is the order under challenge?
Yes, lordship,
Which order you are challenging?
injunction application under Services Act, challenging the impugn order dated 2/8/2024 passed by the learned district judge magistrate at Alipur.
So page. No, you are challenging the order dated 22nd of November 2024.
75, your lordship.
22nd of November 2024. Yes, place that order.
Lordship, they have suppressed and by suppressing the suppressing their they file an application before the district judge and they have filed an application and they taken the plea that the loan amount was 99,000 euros.
Yes.
And that when the matter was came before the tribunal, the same thing was overlooked by the tribunal, and we are ready. Your lordship.
So where is the orders under section 14? Where is the order under section 14?
Order is 92.
Page 92.
Your lordship, my as per 10,71,000, the CA report calculation, the due amount is 2,03,045. I am ready to pay, your lordship.
Yes, we are ready to pay that amount as per CS report.
I am ready to pay, your lordship.
And if your lordship direct us by supplementary agreement, we are filing it.
So this is the order challenge before the tribunal. 2nd of August 2024. What did the tribunal say? Yes. So
Anything more, Mr. Adhikari, you want to submit?
No, my lord, only I am to say that how they are practicing fraud with it. This honorable court is, my lord, that is a constitutional court. My lord, that even the learned deity has not taken note of it. Because the crux of the entire issue is that if I have taken 10,71,000, then there is due of 2,91,000 something like that. I'm ready to pay. But they are claiming it means on the basis of 10,99,000. It is their say how they are proving before your lordship. My lord, may say Mr. Saha is here. My lord, let him convince it if he fails to do it. My lord, that the deity is doing all these things. And my lord, your lordships are here as the godfather at least to save us. And my lord, that we are coming it. And my lord, that all these juniors, they are turning before us. But my lord, Mr. Saha is to see all these things. That first of all, he is to make clear that why it is 10,71,000, 10,000. 90,000. And my lord, one thing, my lord, that if the particular person, my lord, that if they are to, my lord, that they go to every, my lord, that the desk of the bank, my lord, that is it not a, my lord, perjurious, my lord, it is not a criminal contempt, is it not, my lord, that the honorable, my lord, learned trial court, my lord, learned deity should have taken note of all these things. Unfortunately, my lord, all these things have not taken note of it, and my lord, that it has been, my lord, rejected, and my lord, they are going to take poison, and my lord, Mr. Shah has admitted that yes, by police they are going to take poison, but only means that money has not been deposited. Possibly your lordship remember, and your lordship then stopped them. Yes, in the interest of justice, when the Mr. Adhikari is placed in the matter by filing an urgent one, therefore it is such. My lord, I am grateful to your lordship. My lord, I am saying, my lord, that to have, my lord, the complete end of this episode, my lord, only, my lord, that if your lordship will kindly see this CS report, my lord, I am filing it on supplementary affidavit. My lord, if your lordship pleases so, then my lord, let it be fixed on, my lord, that the Tuesday at 2 p.m. My lord, I am coming, and I will personally, I will face it. And my lord, because that there is no that the heaven will fall if they will take poison by tomorrow or the after tomorrow. And my lord, that if your lordship is convinced that no, it is sufficient, means I am convinced that it is 10,71,000, my lord. We are ready to pay the entire amount of 2 lakh something to the bank, my lord, and let here be complete end of this episode.
All right. Yes, Mr.
I'm
grateful
to your lordship. By order dated 17th April, my lord was pleased to
low powers
mobility open. Point of maintainability.
Yes, yes.
My lord, may I be permitted to submit on that point of maintainability at first?
Yes.
My lord, kindly sees this section 18 of the SURFACE Act, my lord.
What does it mean? Section 18? Why section? First of all, convention fact.
My lord,
don't say rubbish before the honorable court.
By any order of the Debts Recovery Tribunal under section 17 may prefer an appeal along with as may be
if it is the wrong, if expressly there is wrong, this is the only question. Say, let him say.
Within 30 days.
Submission.
Within 30 days from the date of receipt of the order of the Debts Recovery Tribunal, provided the different fees may be prescribed for filing an appeal by the borrower or by the person other than the borrower.
You will commit fraud and I will have to go to appeal.
Will be entertained unless the borrower
advocate also cannot exonerate the liability.
Tribunal 50%
submission
of the amount of debt due from him as claimed by the secured creditor or by the determined by the Debt Recovery Tribunal, whichever is less. So, my lord, this order is appealable before the DRAT, which is very much functional.
Even if fraud.
My lord, not only appealable, my lord, they are supposed to deposit a fee of at least 50% of the debt.
You will do it in this way. You will squeeze money.
Not like a 227 petition which can be filed with by paying only 200 rupees. Your debt due is claim amount is more than 5 lakh. If it is 50%, 2,50,000, they had to deposit not 200, 550 rupees for filing this appeal, and that time limit was for 30 days.
About 10,99,000 or 10,71,000, what he says. My lord, Mr. Shah cannot be exonerated. My lord, a perjurious application I will be filed, my lord. I will be filing, and my lord, that he must be made accused.
24.
Because that whether 10,99,000 or 10,71,000.
Can you please allow Mr. Shah to make his submission?
Mr. Shah
will be
is making the same submission that he go to appeal. Court's valuable time is consumed.
Let him
I'm grateful. My lord, whatever late.
This order which has been impugned was passed in the month of November 2024, and this writ petition or the 227 application has been filed in the month of April 2025. So more than 5 months, not 30 days. My lord, kindly sees.
Yes.
The decision of Honorable Supreme Court, I have, in my humble way, I have tried to collect some of the decisions.
Yes.
My lord. এটা কোথায়? এটা আরেকটা কোথায়?
Bank is going to take possession. We are doing it.
Yes, Mr. Shah, what is the decision you are relying upon? This is the age-old judgment. These are recent judgments. So those are recent judgments which considers everything. You are showing a judgment of 2000.
Recent judgments are based on these judgments. Recent judgments are based on these.
All right, 2001 6 SCC 569. Yes.
Sorry, I'm not having another copy of.
Yes.
দেখো তো ওটা কোথাও লেখা আছে কিনা।
Which paragraph you are trying to rely upon?
My lord, I've got. My lord, 5, my lord. Paragraph 5, my lord. In our opinion, the order which was passed by the tribunal directing sale of mortgage property was appealable under section 20 1933 Act. My lord knows that under section 17(7) there is a
problem. You have not got the judgments on Surface Act.
I have.
So that is why it's showing that
Section 77 clearly. I'm coming to that. It says, save as otherwise provided in the Act, dates recorded tribunal shall, as far as may be, dispose of application in accordance with the provision of the RDB Act of 1993 and the rules made thereunder. So, Surface Act is being connected with the 1993 Act by dint of this section 17, subsection 7.
All right. Any other? Yes.
Kindly see, my lord, this one.
Yes. Yes. Which paragraph?
My lord, paragraph 26.
Please say the citation so that Mr. Odhikari can hear that.
2023.
Otherwise, he cannot give his reply.
160.
Yes.
Paragraph 26, my lord.
Yes.
At the outset, it's to be noted that what was challenged before the High Court by the
paragraph.
It is on merit.
Paragraph 26.
My lord, this is a judgment which is not relevant to our case. Why Mr. Shah is consuming the valuable time of the Honorable Court?
India was a judgment and order passed by DRT 1.
Practicing fraud with the court. I'm the last man to tolerate.
The borrower had a statutory remedy available by way of appeal before the DR18.
Let me come in Calcutta.
The borrower would have preferred
Monday's flight. Then you will see.
DRT, he would have to deposit 25% of the due debt to circumvent the provision.
It is on merit. It is not relevance with this case. 10,71,000 or 10,99,000. If it is 10,99,000, then I've got no authority to come before your lordship to come by appeal. But it is not a case of it. The entire amount is disputed, and for practicing fraud, they have subsequently they are bringing 10,99,000. How it is tenable? A bank, whether it is a government institution, whether it can do it, financial institution. It is a fraud with the people.
Petition,
fraud with the petitioner.
6 or 227 of the Constitution.
Creating disturbance for causing damage and to cause
an order
also injury to the mental health.
Yes.
By threatening every time by police that we will take poison, when we have paid the entire amount.
The jurisdiction, obviously, it is quite well settled by the jurisdiction of Article 2.
Only jurisdiction. Why jurisdiction? My lord, I am saying one thing. My lord, he is again repeating and repeating. Whether the jurisdiction is the second question. First question is what?
Certain things. So alternative remedy may not be a bar in certain cases. Also, there are judgments to that effect. My lord, But certain factors are required to be kept in mind, which the Honorable Supreme Court has laid down in the case of
whatever may be, before a court of law, you must have to come with the question. Let him say, Mr. Saha, Mr. Sani order will pass, my lord, against it, my lord, that anything regarding the total amount of loan which is taken by the by the borrower, means by my party from the State Bank of India. Whether it is 10,71,000 but 10,99,000. Here is written somewhere 10,99,000 and another is 10,71,000. What is the actual amount? Let me then answer it, and the CA will file it. I am filing supplementary affidavit regarding the CA's report. And my lord, that I bow down that the another report from the CA also will be filed if they will satisfy that well is such. Let them file a CA's report there, because the constitutional court power cannot be taken away, cannot be abrogated. Constitutional power is the next power. In the Maria's case also, it has been decided in series of cases. If there is palpable malady, if there is principle of natural justice, if there is means that a fraud, then the honorable court can take action into it matter, not going to appeal. Appeal is on the merit. And whether Mr. Saha is, my lord, bypassing the actual question. What is the loan amount? Why there are two versions there? Why it was 10,71,000? The entire means the loan amount. Thereafter, subsequently, it has been inserted 10,99,000. And whether they have paid 10,99,000, that is to be seen. My lord, kindly see that part. Thereafter, whether it is such amount.
30 days already over. Admittedly,
what is it? Whether the question of 30 days, I can come 30 years if there is fraud by the bank. What is the bar? Acta curiae neminem gravivit. Court can rectify its own order at any point of time. Here the means DRT is their man. But it's a captive tribunal. DRT is a captive tribunal. The officers are there only to please the banks, and they will not see if the fraud is practiced by the bank. But my lord, this honorable court will see that this is a practice. What they are doing is deceiving the institution, deceiving the borrowers.
According to
the State Bank, they can.
The loan was for 10,71,000.
Yes, that's right.
So page 65, my lord. So how do you reconcile page 65 and 68?
Oh, this is the moot question. Only 1 minute.
Mr. Bodhikari. Yes.
Can get to.
My lord, Skyly sees there are other charges which are payable.
Yes.
Other charges, banking charges.
Yes.
And that charges are to be recovered from the borrower. So if we add those charges, it is coming to 10,99,000 odd. That is the amount.
How have you calculated that? Where is that calculation? Show me that.
Calculation we have, my lord. I can bring. If my lord directs, I can bring that calculation. That can be done, my lord. No, my lord, kindly sees. The loan of 10,71,000, that was a term loan.
This is your letter, page 65.
65 is my letter. It is
so how have we come to now?
It is an amount sanctioned. But beyond the sanction amount, my lord, page 68, what I stated is it is a part of the 13.2 notice, my lord. Kindly see. A notice.
Page 68.
68 is a part of 13.2 notice.
Yes.
Demand notice. They have not made any objection against this demand notice, my lord. It is a demand notice which was served on them under 13.2, and they were supposed to make objection within 60 days. That is statute says.
No, this surface application was filed only against 14.
No, all against 13.4.
Where is the surface application?
My lord.
Do you have a copy of that?
My lord, they have annexed also, my lord.
Yes, where is that?
My lord, kindly see page 83 is a relief portion which they have paid for.
Page 83.
83. So again 13.2, 13.4 and this order of DM. No, my lord, 13.2, it was filed against 13.2, 13.4. Later on the order of DM came, they filed an IA.
So this is an interim application.
Interim application.
So the impugned order was passed on an interim application.
My lord.
So the main surface application is pending.
And they have not raised any. They were supposed to give an objection. My lord.
Before the DM, why they have stated in lieu of 10,71,000.
60 days. They did not.
Let them place account everything, what amount they have paid and what are the charges, my lord. Let them place, my lord, how it is 10,71,000 to 10,99,000. Let their calculation be placed before the honorable court, my lord.
Odhikari, anything in reply?
My lord, my reply is, my lord, they are practicing fraud, my lord, with Mr. Saha, and my lord, Mr. Saha is practicing fraud with the honorable court. What I am saying, my lord, what I am suggesting, my lord, if bank comes with clean hand, that well, it is 10,71,000, it is the original date, original loan, and 10,99,000 is the loan such. Then, my lord, 10,71,000 to 10,99,000. This variation, my lord, is the main variation because upon which, my lord, I am going to be evicted. My lord, if there is, therefore, it is their say, if there is 10,71,000, then there is no fault on my part. It is their admission because I have paid, according to them, my lord, I have paid the entire amount today. My lord, the bona fide of a person, my lord, in Mardia's case, and my lord, in series of cases, my lord, even my lord, that when the bank, when the DRT has been given that very particular task, and the appellate authority has been given the task, the sole idea was, that means the bank's amount should not be, my lord, should not be misused and by an unscrupulous borrower. Therefore, on that principle, the legislative wisdom means, my lord, that the allowed for enactment of this act. Therefore, if there is any unscrupulous act on my part, my lord, then I bow down, my lord, your lordship will throw me, and my lord, the DRT should be thrown me. But when scrupulously I have paid the entire amount as per their resolution, and my lord, there may be some additional amount which they are going to add. Is it, my lord, that is such a case where such an oppressive measure of police, my lord, that is through police they can take possession? Whether I am saying is such a case, let them show that I am an unscrupulous one. My lord, my junior will show the papers, my lord, and also, my lord, on record.
Mr. Adhikari, have you annexed the application under the surface application here? Where is that? At which page?
My lord, my junior, the Supreme, and my lord,
the application. You have not annexed. And where is the interim application? On which this
surface application is annexed, my lord. Surface application is annexed, my lord.
Where is which page?
My lord. It is annexed.
No, this is the interim application. Page
82 is onwards is surface application.
No. That is the interim application. Where is this main surface application?
Application not annexed.
Interim application is page 82.
In interim application, they have quoted the prayers of the surface.
No. I want to see the surface application. Do you have a copy of the surface application? So when can you give the surface application?
Next week, your lordship. Next week.
Monday?
On Tuesday, my lord, on Tuesday at 2 p.m. let it be fixed, my lord.
No, I only require the copy. Please supply the copy.
I'm having interim.
My lord, on Monday, my lord, I am returning. On Monday by evening flight, I am returning, my lord, in Calcutta, my lord. Then I will place it on Tuesday.
You have made your points. You have made your points. I have heard both of you.
Surface application has not been served.
I'm grateful.
It has not been served.
No.
So please serve a copy of the surface application
that was my
after Mr.
submission
Shah
before the learned
file on Tuesday.
I'm grateful.
Heard the
I'm grateful. Grateful. চলো ঠিক আছে থ্যাংক ইউ
Call the next matter.
full my lord.
Yes. Please serve.
Please, চলো on the yes কি বলেছে হ্যাঁ প্লিজ ঠিক আছে
$242. 242, my lord, I am appearing on behalf of the plaintiff petitioner, my lord. This is the affidavit of service, my lord. There is a caveat.
Yes, you are appealing for the caveat. Yes. Yes, what is this matter?
My lord, this revisional application is, my lord, against the order of impound. Against the order of impound, my lord. My lord, the facts of the case is that the petitioner filed a suit for eviction of a tenant. My lord, the defendant opposite parties appeared in the said suit and filed their written statement. Thereafter, my lord, the defendant filed an application.
Yes, it has been sent to the collector for assessing the stamp duty.
Yes,
How are you aggrieved? Let the collector assess that.
Because of that, this is not the lease agreement, my lord. My lord,
that
once
will be
that application on that documents, my lord, already marked as exhibit A, my lord, the evidence completed. At
that?
Yes, my lord. At that stage of argument, my lord, they filed an application for impound of the said agreement. If your lordship kindly, not only that,
Show me that it was which exhibit?
Exhibit A.
Exhibit A.
Yes.
Yes, after that, how can you do that? It has been marked as an exhibit.
Yes.
Yes, it was marked as an exhibit, but it was a photocopy, your lordship. Subsequently, the original was submitted. There is an order, your lordship will kindly see.
Photocopy was admitted.
Not photocopy was admitted, but it was supposed to be sent for impounding. Your lordship kindly takes up page 92 once. This is the order, main order.
That
after the
application,
impugned order, your lordship.
that order passed in an application under section 114 of the Transfer of Property Act.
Your lordship kindly
That application was
see that order
rejected.
once.
After that, my lord,
with reasons.
argument, evidence completed both the sides. That date fixed for argument. At the stage of argument, my lord, they filed an application for impound, and that application was allowed. Challenging the same, my lord, I have come before your lordship.
Your lordship, page 93.
Page
93, 92, it starts the order.
Yes.
93. It is pertinent to mention that as the defendant has produced the mere Xerox copy of the lease tenancy agreement, the second paragraph, your lordship. As per Indian Stamp Act, the same could not be impounded as per the provisions of the said act. In the future, whenever the said agreement will be produced for perusal of the court, the same shall be impounded.
Yes.
We produced it. We were under the impression it has been sent. When we found out from the records it was not, we made an application. On the basis of that application, this order was passed. Lordship, further, they have said that they have made a objection to our application under 151. Your Lordship, no.
What is the application for impounding?
At page 95, your Lordship,
page 94, annexure 8.
And it's 95.
Page 95.
95 is the pleading start. 94 is the cause title, your Lordship. It starts at 94.
Yes. So if the earlier this liberty was given when it was produced,
my lord,
and they did not challenge that.
My lord, not only that, my lord, that documents was exhibited, my lord, on 19th August 2024.
Now, my 114
at the time of
on that.
What was exhibited? Photocopy or the original?
Original documents was exhibited.
He said photocopy.
No, my lord. No. Photocopy, no photocopy, my lord. Original copy of the agreement. My lord, documents was.
Which was exhibited?
Original was exhibited at the time of deposition, but they did not send it for
then
impounding.
if that was exhibited, marked as an exhibit, how could have been impounded subsequently?
My submission is that.
But they did not challenge this, your lordship. That is why we made the application. My 114 hinges on the fact that I will make a further.
The issue that arises for consideration.
Your lordship,
it appears from the record that the petitioner is appearing in একটু খবর দিতে বলুন। Yes. What is the order under challenge?
My lord, stay order of the match suit till the disposal of the miscase.
Why it was stayed?
It was
Alimony not
stayed.
paid. Alimony not paid.
Alimony not paid, litigation cost not paid, nothing given. Since 2017, my lord.
Yes, Mr. Mukherjee, why are you not paying alimony?
There is no order for paying alimony. My lord, on the last occasion, it was adjourned on the ground that the miscase, that is the matter for alimony, was supposed to be disposed of by 25th. That has been disposed of and the order is here, my lord.
My lord.
That has been disposed of.
That has been disposed of. The order is here.
My lord,
Here.
together with the net copies I am giving
And
you, the previous dates
the
also.
alimony has been declined.
Petition was rejected, my lord.
Alimony has been
I
declined.
was not allowed to argue, my lord. In a month, there were.
To challenge this order.
My lord, my
You
lord,
have
my
to
lord.
challenge this order.
My lord, I'll challenge. My lord, kindly go through the previous orders also, my lord.
And kindly match
The
suit.
net copies, my lord.
My lord, the match suit is at the DW stage. My learned friend's client is avoiding the witness box.
Mr. Mukherjee, have you paid the litigation cost?
It has been ordered on 28th, my lord.
My lord, kindly go through the previous order.
Pay this litigation cost.
That instruction I have to take.
Yes.
Whether that will be.
Kindly go through the previous dates. My lord, in a month, 3-4 days. My lord, this lady is in hand-to-mouth condition, my lord.
Madam, I cannot help. You have to now challenge this order.
I'll have to challenge. But
So,
my lord, during pendency of this
No, my lord,
revisional application that has been passed, my lord.
because the next date is on.
At least grant her maintenance, some maintenance.
no, that cannot be granted from here.
Next date is on 6th of June. And for the match suit, my learned friend's client is not coming to the witness box repeatedly. I can hand over the order copies. এটা দিয়ে দেবেন সুজাত সাথে। On 29th April 2024, PW1, the husband's evidence has come to an end.
So by this application, the prayer for stay was rejected.
Prayer for stay was rejected on the ground that
No cause, urgent for certified. Let's call the next matter. Okay. এসে গেছে নাকি?
41.
Yes.
And for the opposite party, Your
সে
Lordship,
কি খবর দিতে বলি?
40, my lord, I am appealing for the petition.
I'm praying for not today, Your Lordship. The advocate on record is not.
Why you are opposing the prayer?
No, I never.
You never. I will remind this. Application for commission rejected.
2 suits are there, my lord. In 1 suit, the commission was allowed.
Oh, it is that matter.
That matter, my lord.
All right, I'm making it not today.
They appear in the combined list. Combined list.
Combined list, you want this matter to appear in the
No,
combined
the
list?
next day is the combined list. That is why, my lord.
Let us see what can be done.
Item number 1.
Yes, my.
Yes.
বলো
Pardon me, mention, Madam, with the leave of the Honorable Second Judge, Madam, may I mention one matter, Madam? Madam, this matter is in the single bench matter. Appears.
Single bench.
Madam, on
Madam, please don't mention now single bench.
it's extended, but which is
Not now.
very
Madam, we are in division bench. Yes.
Yes, my lord. My lord, I have prayed for addition, alteration, correction of my order dated 9/8/2019.
Yes. What do you want?
I want cost along with other litigation cost, physical pain, mental agony, trauma, compensation, fair value, distracting perusal of my professional life.
Decree was passed, appeal was preferred, appeal was disposed of in 2019, directing me to pay this amount. I have paid the amount in 2019 and we are in 2023.
When this application was filed?
2023.
And what he's asking.
So that amount was received by him without any objection.
Yes, yes, without any objection. And what remains? And there is no lease as of today. Maybe.
Do I
Yes,
decree
Lease today, as of
with
today.
cost, my lord?
This application call the next matter.
After modifying the decree, the amount was paid. And decree was itself awarded with cost, my lord. Together with cost.
Mr. Probal Mukherjee. We have not seen Mr. Mukherjee.
He told me.
My brother has also not seen. We have, both of us has not
He
seen.
was before your lordship in the morning, he's saying
In the morning, his name was recorded. Now we have not seen him.
that he's on that.
Yes. Yes.
That appeal against rejection of review.
Mr. Mojumdar, you are making submissions.
Yes.
Lastly, you are making submissions. Now its composition has changed.
Yes, it has to start afresh.
It has to start afresh. Where is the Learned Advocate
I
General?
told that Learned Advocate General is out of station today.
But someone has to represent the appellant.
Yes, certainly somebody has to represent. Somebody.
Because this was indicated long
Yes,
before.
yes.
Someone has to represent. Mr. Mojumdar, you
They have
can.
informed us, what they have informed us, informed my junior, that Learned Advocate General has requested your lordships that whether it can be taken up on 16th, subject to your lordship's convenience.
16th.
1/6. That's a Friday or any day subject to your lordship. We don't have any problem. We don't have any problem.
Can you inform us about the issues involved?
May I
Brother
just
was
indicate
not-
to your lordship what are the
And,
broad issues?
And one thing we would request both of you, you can communicate to the
Yes.
Learned Advocate General.
Get the notes ready, my lord.
You prepare a short note.
Yes, we are in the
So
process
please
of
hand over that well in advance of the next date. What we will be fixing.
16.
It's not that we will be Mr.
My lord, I
Mojumdar.
think Mr. Adok is there.
My lord, Learned Advocate General, as per instruction. 16, my lord.
Mr. Mojumdar, we will be not be shutting out from making oral submissions.
No. My lord, I understand, my lord.
So if
Time is definitely.
that is because and you have urgency, as you have said.
Yes, we have urgency.
So you have urgency. So now again the vacations are approaching. So only for that we are requesting.
We will get the notes ready.
Please supply the notes well in advance.
My lord, kindly allow us to submit the notes on 13th. we will get the next weekend. So after next
You'll
weekend,
be getting this weekend, Mr.
my
Majumdar.
lord, very difficult, my lord. Now, my lord,
I think your notes are almost ready
almost
because you have made your
I
submission.
made my submissions, but my lord,
Is
just
it that you want for another purpose? One note was prepared.
no,
And
nothing.
change of composition,
No,
you
no,
want
no,
a
no,
fresh note.
no, nothing.
That
It's
is
all the
no-
same. It is all the
No,
same.
no. Maybe all the same in structure what you will be submitting, but
Yes.
for other purposes.
Well,
For other purposes.
no, not that. Not that, my lord. The notes are ready. Well, I just need to go through the notes once more and, my lord, tweak it a little if required.
What is with regard to the Lord Advocate General? Can you give your notes on 13th?
13th, we will give the notes to your lordship. We'll submit the notes to your lordship's officers. My lord, shall we submit the notes to the officers of your lordship, my lord, Mr.
We are not fixing any date. You can serve so that.
13. My lord, if we can do it earlier, we will do it earlier.
Yes, please, if you can do it earlier, you can do it earlier. There is one difficulty. I mean, it will be difficulty for me now.
Right,
And
man.
brother has difficulty because he cannot now say that date because he is part of another division bench. That is the so we can. We are
Generally,
not on the-
Fridays, your lordships, generally, Fridays, your lordships.
Generally, Mr.
No, my lord, we are lord.
So
your lordship.
that date will be indicated
My lord,
well in.
what we will do, it is our duty. We will submit the notes on 13. Whichever date suits your lordship,
So
we will appear and
tentatively,
give them.
we are not fixing any date.
No, I understand, my lord. But my lord, we have some urgency. So, my lord, I would.
We note that. We appreciate also that. For that, we requested you to make your
Get
notes
the notes ready by 13th. My lordship can take it from me. Our notes will be filed.
Will be. I think notes will be better because Mr. Mojumdar, you know the points which the Learned Advocate General has raised. So you can also deal with her. Usually it's after. But due to this situation, since you know what points they have taken, because
We have to understand whether this bench will not be sitting regular.
that is.
We have to arrange our.
And it may be, that is why I've said synopsis of arguments. If both of you after completion want to file any additional, yes, that is why we have couched it as synopsis of argument. Synopsis of argument outlining the would it be possible for you to, both of you, to annex the judgments along with that note?
Prepare a compilation for you.
So please give compilations
Action, something comes, I'll give you kindly answer.
and, no, but I think you have filed the compilations.
We have filed the compilation.
Then you need not tell
Well,
us.
some judgments at the end when I was citing some of it.
Those were not part of that. So you can incorporate only those.
Once again, a full comparison.
We do not have space and the building is sinking. Keep it in your office.
Yes.
So that please don't, only the additional ones, which are not part of the compilation, you can annex that.
Small compilation.
Milord, from your officer, I came to know it is not signed, Milord, order is. That's why, Milord, Monday is the date in the code below. I have to supply the server copy, Milord.
All right. They can.
May I hand over this number?
Yes. And madam, you have to take leave. When you are mentioning a single bench matter before the division bench, you have to obtain leave.
At the beginning, at that time,
You have not obtained leave of my lord. That